My name is Bansa Singh Hayer, and welcome to another series of short lectures presented to you by Dean's Court Chambers. This lecture will concentrate upon children and deprivation of liberty. For those of you who intend to undertake cases in this area, you need to have some understanding of the legislation and case law that surrounds this topic. In particular, you will need to have a working knowledge of the Mental Capacity Act of 2005. You will need to understand the transfer of proceedings and allocation of proceedings between the family court and the Court of Protection. You will have to be familiar with some of the sections of the Mental Health Act 1983, together with the accompanying case law in this particular area. The starting point is what is a deprivation of liberty. This is neatly summarised by Lady Hale in the case of Cheshire West. In short, she tells us that there are three essential components. Firstly, the objective component of confinement in a particular restricted place for a not negligible length of time. Secondly, the subjective component of lack of valid consent. And finally, attribution of responsibility to the state. Practitioners are reminded that where the placement of a child involves such a confinement but is not a secure accommodation within the meaning of Section 25, the judicial sanction can only be provided by the High Court in the exercise of the inherent jurisdiction, or in some circumstances by the Court of Protection. So let us look at the three components that Lady Hale mentions, and it may be easier to look at them in reverse order. Component C, the attribution of responsibility to the state. This is the easiest part. It is obvious where a child is subject to a care order that there is engagement of the state through the involvement of the local authority and the court. Component B, the subjective component of lack of valid consent. Although the Court of Appeal in Re D held parental responsibility is, in principle, exercisable in relation to a 16 or 17-year-old child, for whatever reason who lacks Gaelic competence, the practitioner needs to bear in mind 2 points. The first point is where a child is subject to a care order, neither the local authority nor a parent can exercise their parental responsibility in such a way as to provide a valid consent for the purposes of Component B. Secondly, a foster carer does not have parental responsibility enabling the carer to provide a valid consent for the purposes of Component B. Component A, the objective component of confinement in a particular restricted place for a not negligible length of time. In relation to a child who is subject to a care order, the question whether there is a deprivation of liberty within the meaning of Article 5, engaging the state's obligations, will turn on whether there is confinement. In most of the cases that you undertake, this will be the crux of the case. So the question, what is confinement, is again neatly laid out within the judgment of Cheshire West by Lady Hale, when she says whether a person is under the complete supervision and control of those caring for her is not free to leave the place where she lives. In short, this can be broken down into 2 limbs. Is the person under complete supervision and control? And are they free to leave? These 2 limbs are separate components. These matters were considered by the former President of the Family Division, in Re AF, when as a rule of thumb, the former President said, a child aged 10, even if under pretty constant supervision, is not likely to be confined. A child aged 11, however, if under constant supervision, may, in contrast, be so confined, though the court should be astute to avoid coming too readily to such a conclusion. However, Once a child who is under constant supervision has reached the age of 12, the court will be more readily able to come to that conclusion. Of course, this was as a rule of thumb, and all will depend upon the circumstances of the particular case and upon the identification by the judge, in the particular case, of the attributes of the relevant comparator. Then comparison is not with a typical child the same age who is the subject to a care order. Before leaving the case of A&F, the practitioner should be aware of the guidance provided by the President of the Family Division about applications that are made to the Family Court in relation to children they consider who are being deprived of their liberty, in particular the requirements of their statements, the evidence required, the need for the child to have representation. There are a whole host of matters that the practitioner needs to consider, and one would be wise to read this particular case very carefully. So the leading case in this field is Re D, a decision of the Supreme Court. The facts are quite straightforward. D was 14. He had a diagnosis of ADHD, Asperger's syndrome, and mild learning disability. He was admitted to hospital for assessment and treatment. Within the grounds of the hospital was a school that was integral to the unit. The environment within which D resided was that the doors were kept locked and he could not leave, and he was under constant supervision. The hospital applied to the court for a declaration that it was lawful to deprive D of his liberty in this fashion. The question for the court was whether it was within the scope of parental responsibility to consent to living arrangements for a 16 or 17-year-old child which would otherwise amount to a deprivation of liberty, within the meaning of Article 5, in particular where the child lacked the mental capacity to make decisions for himself. The court held at first instance that whilst the child was under 16 and was deprived of his liberty, it was a proper exercise of parental responsibility to consent to his constant supervision and control. However, by the time he turned 16 and the matter was placed before the Court of Protection, Mr. Justice Kean found that his parents could no longer consent to what would amount to a deprivation of liberty, and that the provisions of the Mental Capacity Act then applied. The matter was appealed to the Court of Appeal, who allowed the appeal on the grounds that parents could consent to what would otherwise be a deprivation of liberty of a 16 or 17-year-old child who lacked capacity to decide for himself, and that the Mental Capacity Act had no bearing on this. When the matter came before the Supreme Court, in a majority of 3-2, the court held the power of physical control was a dwindling right as the child acquired sufficient understanding and intelligence to make his or her own decisions. That the Mental Capacity Act does not override other common law statutory provisions relating to 16 and 17-year-old children. As a matter of common law, parental responsibility for a child of 16 or 17 does not extend to authorising a confinement of the child in circumstances amounting to a deprivation of liberty. Article 5 protects children who lack the capacity to make decisions for themselves from being arbitrarily deprived of their liberty. D's living arrangements had to be compared with those of children of the same age, without disabilities, and the fact that they were made in his best interest did not mean he was not deprived of his liberty. Human rights are about the relationship between private persons and the state, and D's deprivation of liberty in the placement was attributable to the state. There is no scope for the operation of parental responsibility to authorise what would otherwise be a violation of a fundamental human right of a child. Parental consent could not constitute for the subjective requirement under Article 5, full valid consent to the deprivation. So, to recap, if within care proceedings it is apparent that a child is being deprived of their liberty, an application must be made immediately. It should be made invoking the inherent jurisdiction of the High Court, so some thought will have to be given to the appropriate tier of tribunal. If the child is almost 16 or is 16, it may be more appropriate for the application to be made to the Court of Protection rather than being issued in the family court. You will have to consider carefully the contents of the statement addressing the issues. For example, why the test for deprivation is satisfied. What is the regime within which the child is going to live? Whether a psychological or other assessment of competence is required. If it isn't required, why isn't it required? Why is the criteria for Section 25 not met? And why is the inherent jurisdiction being invoked? These are just some of the matters you will have to give particular care to addressing within your statement. Finally, it will assist the court if there is a draft order setting out the declarations that you seek and what it is you say specifically will be depriving the child of their liberty.